Um, I'm excited today to kick off the Fall Clinical Trials Toolkit series. Our first one is the Office of Sponsored Programs Clinical Trial Agreement Review and Negotiation. Today we have Rachel Humberson. She is the Interim Assistant Director from Research Office and Office of Sponsored Programs. And we also have Julie, even though I practiced it, Julie, I'm going to mess it up. I know.
Okay.
Pascuzo, is that right?
Good. Yeah.
Okay. She is a negotiator with the Research Office and Office of Sponsored Programs. Before I read their bios and a fun fact about them, again, we are offering continuing education to WVU employees. So if you would like CEs, please indicate that, and please put your name and email address in the chat for attendance purposes. I'm trying to think if there's anything else. Oh, if you have a question during this, feel free to put it in the chat. We'll be watching it, and I will stop Rachel and Julie and let them know what your question is. And then also there'll be questions at the end today, if you have any. So with that, let me go ahead and I will read about Rachel. So prior to joining OSP, she worked in compliance at BNY Mellon in Pittsburgh for 6 years. She returned to Morgantown with her husband and has worked at WVU for the past 7 years, the majority of which has been with award negotiation team. She is a WVU graduate who first was introduced to OSP while working as an intern in award negotiation during law school. A fun fact about her is she loves outdoor activities and travel, and she's always looking for a new destination near and far that combine both. And then Julie. So she grew up in Carmichael's, PA, just north of the PA, West Virginia border, where she was raised by two proud WVU alumni. She joined OSP in September of 2021. She's a graduate of Tulane University, where she received a BA in anthropology and Cornell Law School. After graduating law school and before joining OSP, she practiced locally as a public defender and as a commercial litigator in New York City. She's proud to officially be a mountaineer and to work with the research community. A fun fact about her is she adopted a kitten on Tuesday, and she is quickly becoming her favorite topic of conversation. Awesome. So with that, I am going to go ahead and turn it over to Rachel first. Again, if you have any questions, please put them in the chat and we will be watching them, okay? All right, thank you.
Thank you, Carrie, for the introductions. Hello, everyone. Thanks for joining us today. It's nice to have an opportunity to give you a little bit of perspective of clinical trial negotiation from the perspective of Office of Sponsored Programs and our award negotiation unit. So the main objectives today, like I said, I want to give everyone, a little bit of background on our processes, start to finish, how a clinical trial gets negotiated, the preferred terms and conditions, and including anything that we, maybe we have more back and forth with our sponsors that, may delay us a little bit in the negotiation process, depending on the agreement and the sponsor. And importantly, we like to discuss the stakeholders that are involved in the negotiation. It's, it's not just happening, of course, on our side. There's, subject matter experts that we work with on a regular basis, and that, really includes, our PIs and our study teams as well. So just initially, I wanted to introduce our team. I think everyone knows we've had staffing challenges this year that we've been tackling, this summer especially. So Eric DeVito is my co-interim assistant director. He's on vacation right now, or otherwise he'd be here to meet you as well. Eric Wanat's a negotiator that's been with our team for a couple of years now. And of course, you just met Julia. Jillian Corbett joined us earlier this year, and has been getting trained as we work through our agreements. Stephanie Herod joined us recently as well, and so did Matt Newsmith. We also have another new hire in process. So we hope, that individual will be able to join us in the very near term. And also, even upcoming, we haven't posted it yet, but we will be looking to hire a clinical trial agreement specialist, someone with some background on the topic that we think would really be a great asset for our team as we tackle these agreements. I also wanted to mention our Huron team, who've been great to work with. And I think many of you may have met them along the way if you're already involved in that, negotiation process. Arden Smith, Danielle Ross, and Lane Whitted. Arden and Danielle primarily have focused on the clinical trials. But Lane also, she's helping our team out as well with a number of items. They've been great. I just, want to note they've been great to work with. As we work with them, it's not just them helping us negotiate agreements. They're really involved in looking at our processes and helping us improve our processes, including, right now we're trying to put together a really detailed training program. Part of that will be to train our staff on clinical trial agreement negotiation. So it's really been positive to work with them. And I think it will make us, onboard our team members quickly and get everyone up to speed, and a really structured, process. And, along the way, they're helping us improve our negotiation best practices. So it's been great to work with them. And on that note, they are helping us out through October. We'll be working with them that, hopefully hand off things after that point in time. But in the meantime, they're going to focus on finishing up the active negotiations for the clinical trials and the other agreement types that they're helping us with. And as I mentioned, we're definitely collaborating with them closely to really enhance our clinical trial agreement process. And just a little disclaimer before we get into the full presentation. It's, educational purposes only. We're not providing legal advice here, so we can't replace our own professional judgment. And, as we may highlight a few more times throughout the presentation, every study is unique, every agreement's unique, and we have to approach that accordingly. And so, there's not always, one answer for all agreement types and all studies. So the first step, how we really get looped in on a clinical trial that's coming our way, especially in the industry sponsored side. A non-disclosure agreement is provided by the sponsor. That comes to us. Someone on our team will review and negotiate that document. The point of that ultimately is so they can share their protocol with us. And then we, our study teams can make the determination whether they want to proceed with the study. And just a quick note, if you, just as a point of reference, if you ever have questions or draft CDAs or NDAs, we do have a vanity account specific to that. That's cdaosp@mail.wvu.edu. After the CDA is complete and, maybe our study teams have decided to proceed, generally what happens is a budget negotiation that's occurring before it gets to us. We typically want to have that finalized before it gets to us, before undertaking a really lengthy clinical trial agreement negotiation. You want to make sure that, we can first come to terms on just the budget and the numbers. And so that, once that comes to us, then we're typically ready to go and start with our process. And so I will hand it over to Julia here to talk a little bit about the steps that occur once it does arrive in our inbox.
Hi, everybody. I'm Julia. I think before diving into this, I think it makes sense just as somebody new to OSP, I think it's useful information too to understand how our office and OSP is structured. We kind of have, well, not kind of, we do have three sub departments in OSP. There's pre-award, the negotiations, and then award initiation. So Rachel and I are in the negotiation group, and we are negotiating the CTAs. But the first step and how it gets to us is usually through working with the pre-award unit, where the proposal summary sheet is submitted to them, the negotiated budget, as Rachel discussed earlier, and an initial draft of the clinical trial agreement are uploaded. And then that triggers a notification to us in award negotiation, and we then add it to our queue. We have a running spreadsheet where we add new items by the date received, and then Rachel, who is our assigner, will assign it in accordance with the order received. Usually the oldest in the queue is the first to go out to a negotiator, unless there's some urgent circumstance or some priority that will bump it up. And then that gets assigned to us through our Trello board, and then the individual negotiators will reach out to the clinical team at that point to let you know who's working on the clinical trial and start with questions. Next slide, Rachel. So once the negotiator gets the clinical trial, their first step will obviously be to take a look at the file and see what's in it. And one of the most important document is that draft clinical trial agreement. That's going to be the binding legal document. Usually the budget gets attached to it and has all the terms and conditions. These are really lengthy and dense documents. The initial review is probably the lengthiest part of the negotiation for the negotiator, as far as actual time spent with the documents, other than waiting for responses, etc. The CTA itself can range in length and density. It can have really standard terms. It can have really unique terms. Depending on that individual document itself and the individual negotiators' volume of other contracts, kind of determines how long it takes to get that initial review done. There are some clinical trials that are easier than others. For example, if we've already negotiated a master agreement with the sponsor, usually the terms will either just be incorporated by reference, or you can kind of just quickly review to make sure that they all match up. And some are also, amendments, or like the FDP agreements, like the federal, like some NIH studies have a master template that is just really straightforward and easier for us to get through more quickly. Next slide, please. So when we do take a look at that contract, we have a few tools in our arsenal to help make that easier for us, to make sure that we are protecting the university's interest first and foremost, and complying with standard practice in the industry. We use, our main tool that we have is, we have a checklist that's created that we go through and make sure that we mark off which terms are standard and which terms that are preferred that are included, or which ones we need to insert or try to negotiate. We also have what we call a playbook that has preferred terms and different rationales listed out to help us with comments to negotiations and why we're changing certain terms. And we also refer to two industry standard samples from Magi and from ACTA. Again, there's no one size fits all approach. So each contract is going to have something unique. I don't think I've experienced one yet where I didn't have a question that fell outside of those four tools. But luckily, we have a group of individuals who have lots of experience and or critical thinking skills, and we're able to find a good answer. Another thing we also rely on too is looking at recently negotiated agreements with sponsors. For example, like if we have a sponsor that we use regularly, it's helpful to go back and look at things that we've already done with them, because it might make things quicker, or we can see that, you know, they've already agreed to this before, so why don't we try to insert this again to protect West Virginia's rights? So that's a helpful tool as well. And that makes it more efficient and more effective, honestly, with what we're able to accomplish. Next, please. So at that point, we review the agreement and we create a red line. There are certain items that we need to get feedback on before we can send our draft to the sponsor. There are study specific questions. We might go to the PI or the study coordinator. And we'll talk more about this in later slides. There are other stakeholders like risk management and the COE, et cetera. Once we have a red line where we can go ahead and send it out, we'll send it to the sponsor. And then we wait. This is what happens. We have to wait for the sponsor to get back to us. And usually, like, the length of time that this takes really depends on, you know, that sponsor's workload, our history with the sponsor, et cetera. And sometimes there's some back and forth. There may be several drafts in the process where they send us comments on our comments, and we send back more comments, and it kind of goes on for a little while until we settle the agreement in a way that's mutually beneficial for both parties. Yeah, I think that's all for this slide. Thanks. So for all of our contracts that are CTAs, WVU is the party, right? I'm sure you've seen some, maybe you've seen some agreements where we use West Virginia University Research Corporation, but for CTAs, West Virginia University will always be the party. And this is done for a couple of reasons. WVU is a state agency, so by West Virginia law, we're prohibited from entering into indemnification contracts. So that gives us a certain level of protection. We also get sovereign immunity as a state institution. And for our insurance purposes, WVU is the preferred option because it doesn't carry the excess liability policy and it creates a cap on insurance coverage. I'm sure some of you have experienced PIs sometimes do sign agreements. Usually they do sign CTA agreements, but as read and acknowledged only. Generally speaking, PIs are not party to the CTA as a personal entity. Next, please. WVU hospitals are sometimes looped in as a party to the CTAs, sometimes not. It just depends, again, on the content of the CTA itself. Obviously, studies frequently use hospital facilities, hospital employees that aren't WVU employees. And so at the beginning of a negotiation, we'll reach out and ask, are there any WVU employees or facilities being used? And that kind of guides us with our discussions with WVU hospitals. If it's a device study, also we will, or involving installation of equipment in the hospital, we'll definitely loop in WVUH, at least for feedback if they're not going to be a party to the agreement. We're in the process of increasing our communication with WVUH as throughout negotiations, with the goal of preventing holdups late in the clinical trial review process. So instead of waiting till the end to contact when we're negotiating some term about a hospital employee or a hospital facility, we're trying to front load that as we're modifying our negotiation process. An example would be like if equipment or device purchase is going to be used on the premises, that would need to go to WVU hospitals procurement for review. So we try to get that out to them early in the process so we can get their feedback earlier as well. I think another example that I've experienced too is one time there was a hospital employee that was not a WVU employee, and there was one particular term in this CTA that I was negotiating that required proof of insurance for all people involved in the study. So I had to work with general counsel for the hospital to make sure that there was proper insurance coverage. And with that, I'm going to hand it over to Rachel to talk to you about some preferred terms. I think you're muted, Rachel.
That's important. Thanks for that, Julia. Yeah, I just want to walk through, some of the terms that we do see in our agreement negotiation process. These will mostly show up in almost all of our clinical trial agreements, and we'll have to address them. First, I think, if you've, any sponsored research, as an institution of higher education, we don't, we want to have academic freedom. We don't want to give up our right to publish because of that. And so, what we'll see in these clinical trial agreements, usually if it's a multi-site CTA, there'll be some specific publication language to that. So ultimately it would permit us to publish typically. The question comes in is, what is the delay? Because they want to put out, more of a larger multi-site publication first, the sponsor does. And so, there's language that will address, for 12 months after the study is complete, you can't do an individual publication while we're working on this larger document. However, once that time period has passed or the determination is made to not publish a group publication, then us as an individual site can gather our results and publish should we so choose to do so. And so what you're seeing on the screen is a preferred term. So that after the multi-site delay in our agreements, we'll typically insert something like this, that we will have the right to publish, subject of course to not publishing their confidential information. But then there's a review and comment period that the sponsor has over the document. So we send it to them. They get an opportunity to review it, make sure we're not, releasing any confidential information. And, after that period, then we are free to publish. Occasionally you'll see approval language, the sponsor has to pre-approve the publication before it can be shared. And that's, definitely something we avoid. And that applies to basically all of our agreements. And this ties in, relates in part to publication, but we do, there's always going to be a confidentiality term. Our sponsors will define that pretty broadly most of the time, trying to capture, almost anything that's provided as part of the study and their definition of confidential information. So, I mean, that, as a state academic institution, we want to share knowledge, as indicated in the, wanting to publish. We want to share it with the general public. So, we have to work out these two interests. And so part of our doing that, we have, certain defined exceptions that we want to carve out of their definition of confidentiality. So that's a focus in the negotiation. There can be a little bit of back and forth there just to get the language to make sure it's not too broad. One thing we're trying to make sure we carve out is, publication. So we want to be able to use our results for the purposes of publication. So we have to ensure that the term is defined accordingly, so that we can still do that. And we have
Rachel.
Sure.
I'm sorry to interrupt. You had two questions in the chat.
Okay.
The first one was, would you be able to share the slide deck after the presentation?
Yes, we absolutely can do that.
And then this question, it says, knowing that the industry, an example, pharma, medical devices, CTAs are different than government sponsored. And that example was NIH, NSF, DOD. And it says CTAs, what sort of workflows or processes are in place to accommodate the expendency of CTAs for the sector?
I think if I think I understand the question, is it directed at, what processes we have in place to expedite the CTA reviews versus by type, or maybe I'm not quite.
I don't, Allie, would you unmute yourself and just, yes, she said yes, yes.
Okay. I mean, I think Julia indicated as far as, generally speaking, it arrives in our inbox. They are, assigned in the order received. As far as differentiating, it's just a matter of, conducting the negotiation, as knowing that you have all of these pieces playing into it. So as soon as you realize, that's why we've started looping in the hospital immediately. So as soon as, if there's something that requires their feedback, rather than late in the process. If we encounter, anything unusual, say from an intellectual property perspective, we encourage our team to really reach out to our subject matter experts in that for, and that would be tech transfer in that case. But really it's just a matter of us, the training to be aware of who to talk to when these issues occur, and how to promptly address them.
Can I add one thing to that, Rachel?
Sure.
I think also when, again, going off of Rachel's last statement, that it's just training all of us in award negotiation are aware to look for prior examples. So when we see something come up that's NIH, NSF, DOD, et cetera, like immediately when I open that document, my alarm bell goes off and I go back to our database and I find a prior negotiated NIH document, for example, and I'm able to quickly compare the standard terms. And then if there are oddities, then I go from there.
Yeah. Thanks, Julia. Yeah, it is definitely, for either type of clinical trial agreement, that's, a first step that, we have everyone try to do is just look for prior history. It can definitely save time on our negotiation process. Just wanted to make quick mention of AHARP accreditation. That goes through our OHRP office. They handle, the accreditation requirements. However, there is a piece of that is in our clinical trial agreements, and it is required for our accreditation purposes. So what we have to add or ensure is included, because our sponsors do occasionally give us at least some version of this language, is the requirement for the sponsor to basically notify us if something occurs while conducting the study that may impact our patients' health and safety, may change our IRB determination, or may just change the way we want to conduct the study, or anything to that effect. So we have to include some, a version of that language in our agreements, and we do, occasionally talk to OHARP and just make sure we're on the same page with items like this. Intellectual property and ownership of data, that that can occasionally become a sticking point in an agreement. From a standard research agreement perspective, our position would generally be that we either own or we jointly own our IP and data that result from our conducting the study or the project. We see an exception to this with industry CTAs. They've built the protocol. This is their idea. This is their drug or their device. And so in that case, it's the end result is generally the sponsor is going to own the IP and the data that result from our use of their protocol. And so, yeah, it's basically just, it's kind of an exception to our standard approach because of the nature of a clinical, an industry sponsored clinical trial agreement. And that's also, it's not likely we're going to, develop an invention on our side, of course, if, the belief is otherwise, we always, take that into consideration as we're informed of that. The sponsor needs, as far as owning the data, the sponsor needs to own that data because they're developing a product, and that's critical to doing so. So, what we do just to sort of protect, going back to being a public benefit for what we do in our research projects, we add language into our agreements where we request a license to use for our own internal non-commercial research and education purposes and for purposes of patient care. This actually ties into sort of an issue that, may not always be apparent. And that's just maintaining tax exempt bond status for the university. And I do have a few more notes on that. So just as an aside, some of our facilities are financed by tax exempt bonds. And so really what we need to do is ensure we're providing a public benefit for our research, which we carve out in a clinical trial through maintaining our ability to publish, which I mentioned earlier, and our ability to use the data as a result of the study for, for our research purposes or whatever it may be. A PI initiated clinical trial will be a little different. One of our investigators has an idea for a new use and develops the protocol. So at that point, we really become the sponsor of the study, and we have to assume, risks accordingly. And so, from an IP perspective, we try to, maintain a lot, more of an interest in whatever results from that study because, we did. Our investigator did develop this idea and ultimately, has a goal for maintaining an interest in, whatever may result. And we do, again, we coordinate closely with our experts in the field as these situations arise. Okay, governing law, because we are a state agency, we cannot agree to the governing law of another state. These clinical trials almost always arrive to us with, another state's governing law, absent some prior history with the sponsor. So that's a negotiation point. We will try to either agree to West Virginia law or to remain silent. I can tell you the usual end result of that is remaining silent as to governing law. And on the liability side, and this is really getting into an area where there can be some back and forth. Again, we as a state agency, we cannot enter into contracts of indemnification. That's just tying back to our state constitution and case law, and we just can't agree to indemnify or assume the liability of a third party. And so what's on the screen is in italics is our preferred term, which is basically just agreeing to be responsible for our own acts and omissions, negligent or wrongful acts or omissions. It's generally agreeable. I think our sponsors are aware that of our limitations. They deal with other institutions that have the exact same, the exact same requirements. And so you can typically come to an agreement on this language. So for the sponsor initiated studies, our sponsors, on the flip side, should be providing indemnification and reimbursement for any injuries that may occur to the patients during the study. And this is where we can really get into the weeds on negotiating the agreements. There's, little, carve outs and limitations that our sponsors will sometimes build into this language. And it really requires that we be, careful in our review of it to make sure we're protecting the institution and of course our study subjects. And so we do have some, like I said, some back and forth on this language until we, reach an end result of, beneficial to the university. And one thing we do, one thing this ties into is, our coordination with the Center of Excellence and the Risk Assessment Committee. So we, part of their process is to consider risks. Consider the risk, but consider these two terms, which is, the sponsor indemnification and the sponsor's willingness to reimburse for subject injuries as part of the overall, review and approval process on their end. And so we're in regular communication on that front with them, just letting them know as soon as we have that language finalized. And with that, I think, Julia.
Yeah.
And I guess we just kind of jumped over into your slide here, but
that's okay. It's a good segue. So as Rachel was saying, I think it's really important to note, and I think the next couple of slides will highlight this, that award negotiation works with a lot of different stakeholders as we're going through our negotiation process. And one of the most important players that we work with very regularly is the Center of Excellence. They have their own review going on for every clinical trial at the same time, at the same time that we're doing our review of the contract document. So there are the subject injury and the indemnification terms are very important for the Center of Excellence to evaluate the risk. It factored into their overall approval or denial. For a clinical trial that's actually been defined as a clinical trial and registered as a clinical trial with the COE, we cannot sign a CTA until we get the COE's approval. And we do this when we're negotiating. One of the things that we'll negotiate back and forth on are the indemnification and subject injury language. Once we get that to a point where we feel that it's final, we'll go into KC and upload and send it to the COE for review, and they'll come back to us and say whether they approve or deny the CTA based on their whole finding, but they won't approve or deny until they hear from us on those terms as well. So it's kind of a symbiotic relationship almost, where we both have to be ready to move forward before signature can happen. So that's one way we work with them. We keep each other up to date regularly. I actually owe the COE a list, so I'm trying to get that to them today. But we keep each other informed on all of the status of these terms and whether or not agreements are approved. I mean, trials are approved or not through the COE's process. And sometimes in award negotiations, we'll get a document that looks like a CTA, walks like a CTA, talks like a CTA, but isn't registered with the COE. And so we'll have to reach out to the clinical team and get some more information and talk to the COE and make sure that it's a registry trial and not actually a clinical trial, and no registration is necessary. But we'll always do that before we go to signature on those kinds of documents, just to make sure that we're not moving forward without proper COE approval. Next, please. Another group that we often work with is the risk management group. This is, we work with them across the board on a lot of our contracts, but our preferred insurance term is listed here. It's the $1 million per occurrence with no aggregate limit. And as I talked about a little bit earlier, that's our cap. If things are non-standard, we'll reach out to risk management and give some information to risk management and try to talk about what we can agree to and what we might propose back to the sponsor. And again, there are cases where, again, there are CTAs that aren't real CTAs. They just look like a CTA and maybe have like an opioid that's being used or something. Then we'll need to go to risk management to get the proper insurance coverage in place. Well, it's in place. We need to get the proper insurance language in the contract that properly reflects what we can do. Another thing, like I've already mentioned, this example would be when hospital employees need to be insured. We'll coordinate with risk management and the hospital to make sure that we're meeting all the requirements for the language of the CTA. Sorry, I stuttered over that one. Next, please. So I just covered two of these main stakeholders that are on this list, but like I said, there are several in the hospital and the university that we reach out to regularly that really are essential for us to be able to negotiate. I can't underscore the importance of the clinical team and the PI and their knowledge. We get papers and we can read the protocol, but none of us in the office are doctors, one, and two, the protocol doesn't always really get you down to the nitty-gritty of what's actually happening. And sometimes that can really affect whether or not we can accept a term. Very recently, I worked on a registry trial, and we were stuck on two terms, one related to how the sponsor would store data and samples. It was related to a blood draw and a test. And the second was related to their indemnification clause, what they would be liable for if something went wrong. They were insisting they'll only be liable for something going wrong with the data and not something a physical injury to the patient as a result of the blood draw. Now, those are two things that we normally wouldn't really agree with. Limited responsibility related to samples and data and taking away liability for patient injury. So there was some back and forth with the clinical team about whether this was standard of care or not. But we actually got on the phone and we talked about how the blood draw was happening, and it was a third-party blood draw that was going to have a battery of tests that had nothing to do with the study. It was just one test being run from the same blood draw. And once I understood all of that, it became clear that the sponsor's position made sense, that they wouldn't be liable for the prick and they wouldn't be liable for storing the samples in that case. So we were able to resolve that issue after a simple conversation, just to make sure we were all speaking the same language. We already talked about the Center of Excellence and what they can do and risk management. We'll go to the Office of General Counsel for various questions of law. Rachel talked about some non-standard terms. Actually, I reached out to OHARP for that data issue in that same CTA. IT and Office of Tech Transfer, they're all integral to our process. Rachel's been doing this a lot longer than I have, so I'll turn it to her if she has some examples from those stakeholders, but otherwise, that's all I have. Thank you.
Yeah, with general counsel, it can come up in really any term in the agreement. If there's some unique regulation incorporated into the agreement for some reason, they may do some background research for us, make sure that we can actually agree to it. I think we've given some, Julia gave some pretty good examples with OHARP and with ITS. I mean, I think everyone knows there's a very big focus on data right now, and securing our own data and also securely transferring data to other parties. And so terms may be in the agreement that cause concern, or the method the data is being transferred may need a little additional review. And so that's where ITS may come into the picture, and we may ask them for feedback on if this is acceptable. Even the language, occasionally we'll have them opine on the term itself because it's IT specific. I think we covered OTT and IP. It just depends on the language and whether if it's PI initiated or not. And Julia covered risk management. So I think that's the bulk of our stakeholders. All very important to the process, all very important to getting our agreements signed and these studies underway. And it's we all work pretty well together, and we're grateful for everyone's expertise in that in these and it's amazing how much can many different people may have to opine just to get one agreement finished. So clinical trials are definitely an example of an agreement that sometimes requires that. So before questions, I just wanted to point out the text on the bottom here. If you want to send, if you have a CTA amendment that arrives, I wanted to point out our group mailbox here, which is OSP award negotiation @mail. That's where we try to direct new agreements and new amendments. And then from there they get, entered into our inbox. We also have a new form, if, we've been working on communicating that. So I wanted to include that. If you do have a status update request, an agreement is with our group, but you don't know where it is in the process, or you haven't yet talked to the negotiator that's involved, there's a link. You can actually find it on the KC dashboard. Hard to convey the hyperlink here, but it will be in the presentation that's shared as well. But that form just allows you to submit a request, and our goal, and once we receive them, is to respond with, within a business day, no less than 2 days, to let you know where your agreement is. And with that, if we have any questions, we'd be happy to answer them.
Hi, Rachel, Julia, thank you for a wonderful presentation. This is Dan Lucas. I'm, I guess, asking a question down from CMC, and so the context maybe, I just want to give you that for context. I was just curious about how much volume that you guys see coming through, and whether or not you are reviewing the agreements for the whole university or specifically for the medical side. And then percentage-wise, what would you say of the volume that you do, if it's for the entire university, what percentage of agreements come through the medical school? And I'm the context for my question. I'm kind of thinking about what we do down here, and thinking about our staff, and you guys have a well-articulated and well done process set up. And again, I'm just thinking about what we do down here and how we handle it, and the overlap and so forth. So that's the reason for my question.
Yeah, so any agreements that are tied to research, at WVU are coming through our sponsored programs office. I can tell you, I don't have specific numbers on the top of my head. It's been a very high volume for 2 or 3 years now. So I can make a note to get back to you with the specific details there. But yeah, it's all the sponsor research agreements that that are occurring at WVU come to us. I can't. It's really a wide variety. It's hard to give you a specific breakdown off the top of my head, but we do, sponsored research, clinical trial agreements, CDAs, NDAs, MTAs, it really a wide variety. DUAs are also coming through our office as well. So we're fielding a large variety of agreement types, and working with, our team, to address them. So if it's okay, I can make a note to follow up with you on, more specific numbers.
Yeah, that would be great. It kind of gives me a stance from the perspective of, at times I feel like we're not as resourced as well as we could be. And some of what the business associate agreement you just mentioned, it seems like we go through the privacy office for that here. And it might be nice to have more of a coalesce process like you guys have set up with a specific office to handle some of these matters. But yeah, that would be great. Thank you.
Okay, can you give me your name one more time so I can write it down?
Sure. It's Dan.Lucas. It's LUCAS at camc.org.
Got it.
Again, thank you guys for a great presentation.
Yeah.
Does anybody else have any questions? Okay, well, I want to thank you guys for presenting today. You did an awesome job. And again, if you want CEs, please indicate that in the chat. I will be sending out a survey, and a few of you have requested the slides. And we hope that you guys will complete these surveys, and on there it'll ask if you have any training ideas for us, like topics that you want to hear about. So I encourage you to fill those out for us. But we're going to give you 8 minutes back, and I hope everybody has a great weekend. Okay. Happy Friday.